friends and guests to this webinar. I'm glad to present this group. The Council of Economy and Labor has been interested several times with the issue of labor rights, of course, mainly indeed concerning the national scenarios. Now we are more and more confronted with the need to promote and make effective these labor rights beyond the national borders. And in fact, many of us have been trying to see how the best instruments to reach this objective. Last year, in the centennial of the ILO, we ourselves have participated to many debates on how to promote labor rights internationally, social clauses in international trades, etc., etc. Well, this objective is certainly not easy to pursue. Some progress has been made, as far as I have seen. But of course, the road ahead is still long, particularly procedures of enforcement of these rights beyond the national borders are still rather weak, and they are not supported, indeed, in many cases by the national authorities in the states. In fact, some states are working against the internationalization of labor rights and into interstate cooperation. So we, all of us, are committed to analyze and promote the good cause of international labor regulations. For this reason, we have decided to present here the recent agreement, US, Mexico, Canada, and I'm glad that we have a speaker, excellent speaker, Lance Compa. In fact, I have been reading many papers written by him, and I know that he's really an expert in the field. I'm glad to have him here and to see him also by way of our web. So thank you very much. As you will see, Michele Faioli will present the roundtable and the discussion after the speech of Lance Compa. Unfortunately, we are rather tight with the time, and so I ask you to begin immediately. Thank you, all of us, and have a good discussion.
Thank you,
Michele.
Tiziano.
Oh, yes, Lance.
Michele, do you want to speak? Okay, I'll begin.
Lance, okay, go ahead.
Thank you, Tiziano, and thanks to Michele and all the colleagues who organized this webinar. My presentation has 4 parts. First, a summary of the new United States-Mexico-Canada trade agreement. Second, a summary of the new labor law reforms enacted by Mexico as part of the trade negotiations. Third, a description of a special new enforcement mechanism never before included in any trade agreement, called the Rapid Response Complaint System. And finally, some thoughts about what the North American agreement implies for future trade negotiations between the European Union and the United States. First, to summarize this new agreement. We call it in the United States sometimes the new NAFTA, but the official name in the United States is United States-Mexico-Canada Agreement. In Canada, they call it the Canada-United States-Mexico Agreement. In Mexico, they call it the Mexico-United States-Canada Agreement. So in each country, da casa, they put their own name first. With all due respect to Canada and Mexico, I will use USMCA, United States-Mexico-Canada Agreement, to refer to this new accord. The three countries negotiated the USMCA in 2018 and 2019. They ratified the agreement in early 2020, and it went into effect on July 1st, replacing the NAFTA, the earlier North American trade agreement that had been in effect since 1994. And this new trade agreement includes a totally new labor chapter, Article 23 of the agreement. In the USMCA labor chapter, the three countries assumed two principal obligations and a dispute resolution mechanism that allows for trade sanctions against a government that fails to meet its obligations. The first obligation is to adopt and maintain national laws consistent with the 1998 Declaration on Fundamental Principles and Rights at Work of the International Labor Organization. As you know, these cover freedom of association, forced labor, child labor, and discrimination. I should note here that the United States interprets this obligation to adhere to the core labor standards of the ILO as applying only to the broad principles of the declaration, not to the 8 conventions that are associated with the 4 core standards. You probably know that the United States has ratified only 2 of the 8 core labor standards. So it did not go farther, and so there's a footnote in the agreement which actually says this means the declaration, not the conventions. The second obligation assumed by the governments is to effectively enforce national labor laws on the ILO core standards, and also on what they call acceptable conditions of work, on wages, hours of work, and occupational safety and health. The new labor chapter also introduced new commitments to prohibit the importation of goods produced by forced labor, not from each other, but from any other country, to end violence against workers because of their trade union activity, which has been a problem in Mexico and occasionally, honestly, a problem in the United States too. And to end discrimination against workers based on sexual orientation or sexual identity. In another novel provision of the new agreement, it contains special salary requirements for the automobile industry. It says that 45% of the value of each vehicle must be produced by workers making no less than $16 per hour. The purpose here is to persuade companies to keep jobs in Canada and the United States rather than move jobs to Mexico where the wages are much lower. The USMCA creates a dispute resolution system with 3 stages. First, an opportunity to resolve problems through government-to-government dialogue in a very friendly context. Second, a more formal consultation process between the governments, which can be more contentious. And then finally, dispute resolution by arbitration, conducted by an independent arbitral panel, which is empowered to impose trade sanctions, the suspension of tariff benefits under the agreement, if it finds that a country has failed to enforce its labor laws. Now to the Mexican labor law reforms. One of the most important results of the USMCA is an extensive labor law reform that Mexico enacted in May 2019. This is a significant point. It was because of the trade agreement, in connection with the trade agreement, that Mexico agreed to break up the traditional, what is called protection union system that has prevailed in Mexico for decades. Under this Sindacati di Protezione system, workers do not choose their union. Employers choose the union, a union that will protect them against an authentic union coming in to represent the workers. That's why it's called a protection union system. In many cases, employers and unions make their arrangement even before the workplace opens and before any workers are hired. Now, until now, a tripartite labor board system of government, employer, and protection union representatives has maintained this system. All three benefited from it. The government attracted investment, employers got labor peace, and unions got dues money, le quote, usually 2% of salaries paid directly from the employer to the union, bypassing the workers. So nothing is actually contributed by the workers. It's just a payment from the employer to the union. The new reform law replaces these tripartite boards, first with new labor courts in the judicial branch to handle labor disputes, both individual and collective. The law also replaces the tripartite boards with a new federal agency to protect trade union rights. Now, this change has not taken place instantaneously. There's a 4-year transition process which has just begun. So this is still a work in progress. The labor law reform also introduces new levels of transparency. All collective bargaining agreements will be put online at the new federal agency and made publicly available. The reform law requires secret ballot votes on ratification of all collective agreements and for election of union leadership. It requires a secret ballot vote when 2 unions are competing for bargaining rights. Typically, the existing protection union against an independent union seeking to replace it. Just last week, in one of the first elections under the new system, workers at a Canadian-owned mining company in Sinaloa, Mexico, voted to replace their existing protection union with an independent union. Now about the rapid response mechanism. This mechanism allows complaints against an employer, against a company, not just a complaint against a government, which is the normal complaint mechanism under this agreement. The rapid response system is limited to freedom of association issues only, the right to organize and the right to bargain collectively. It aims at violations at a specific workplace, a specific facility, a factory or a call center or a warehouse or a mine, something like that. A rapid response complaint requires only a good faith belief that workers at this particular workplace were denied their freedom of association rights. There is no requirement to exhaust domestic legal procedures. This mechanism also creates a rapid dispute resolution system. It allows for a 45-day period to resolve disputes amicably, but if it is not resolved, the complaining government can compel formation of a 3-member rapid response panel that will investigate the situation and determine if workers' rights were violated. When the panel is formed, the complaining government can provisionally apply trade sanctions against the company, putting the company on notice that its exports are subject to retroactive tariffs if the rapid response panel finds that there was a denial of freedom of association rights. The panel would normally make its determination within a 60-day time frame. So you can see this is relatively a very rapid procedure. This 3-person rapid response panel, they are not government officials. They are private sector individuals drawn from a list of 6 US nationals named by the United States, 6 Mexican nationals appointed by Mexico, and 6 non-US or Mexican nationals jointly chosen by the 2 governments. The American unions announced just 2 weeks ago that they intend to file the first complaint, or to ask the US government to file the first complaint under this rapid response system within the next 3 or 4 weeks. So we'll see if this first case arises and how it proceeds. Some final thoughts on European Union and United States trade negotiations. This USMCA raises many questions about how the European Union and the United States would approach these issues. For example, the European Union has required its trading partners in trade agreements to ratify all 8 of the ILO core conventions. In fact, Canada and Mexico did ratify all 8. They had ratified fewer than 8 before, but in connection with the trade negotiations with the European Union, they went on to ratify all of the other core conventions. Will the European Union demand that the United States ratify all 8 core conventions as a condition of a trade agreement going into effect? Especially conventions 87 and 98 on trade union rights, which the United States has not ratified. The United States insists on enforcing a trade agreement by arbitration and economic sanctions. The European Union calls for consultation between governments to address problems. Europeans want diplomats to handle labor complaints, not lawyers. Which side will prevail? The United States with economic sanctions, or the European Union with diplomacy? These are just a couple of examples of many complications that will arise in European Union, United States trade negotiations. But I will stop here, since I'm eager to hear the presentations of other colleagues in this webinar. Thank you again for the opportunity to present these ideas today.
Well, thank you very much, Lance, for your keynote speech. I'm very happy to introduce now the roundtable. Before, I should say that Lance Compa, with another of our friends and colleague, Janice Bellace, is part of the committees, the panelists of the labor mechanism, the rapid labor mechanism. So it's a very important presence in this virtual panel, because we can understand also the real problem. So what we have now in the round table, I would like to focus on 3 main points. The first point is how does the USMCA change things? The second point is everyone so positive? And the third point is what held up the USMCA for the future? And these 3 points are very interesting. Why? Because if we go back to what we were used to study and to write in our paper, we often stressed that the real problem was still there, because if we look on the Canadian-European agreement or other mega treaties, as someone said, the frame treaties between peer-to-peer states, we can understand that there is no effective remedy to labor violation within such legal frames. In other words, normally individuals cannot complain in front of the judge for obtaining protection for some kind of violation and so on. While on the other side, corporations are usually vested with rights and can obtain a sort of justice in front of arbitration panel and so on. So there is something like an unbalanced play field under the treaties, the trade treaties, that someone stressed as, as not a good thing. So for that reason, maybe the labor chapter of the USMCA could be considered a new gold standard for labor protections. Is a new vision for the labor protection in mega treaties, trade treaties. So if this is true, during our roundtable, we should understand why, to what extent, and what held up for the future, I mean, what we have. And for that reason, I would like to leave the floor, first of all, to Luca Visentini, the General Secretary of the European Trade Union Confederation, to understand his viewpoint concerning the vision that the European trade unions have developed on this topic in relation to the European trades with other countries, countries that we consider as partners in trade, in international trades, and can become in the future. Do not forget that we have still on the table the trade agreements with the US, the famous TTIP that was not closed. Maybe it will be changed, we do not know. But this is a starting point also for the future. Please, Luca, take the floor, and we have unfortunately a limited time, so we should stay no more than 10 minutes, 7-10 minutes. I will indicate you when we are around the 7-8 minutes. Thank you. Please, Luca.
Thank you very much, Michele, and thank you very much, Professor Treu, for organizing this very interesting discussion, and thanks to Lance Compa for having introduced the novelties of this very important agreement, the new NAFTA, as you call it. To try to reply to the three questions that Michele introduced, I would like to address the problem from an European perspective. As we all know, I mean, the European Union has very limited and few exclusive competences. Among those, there is trade. This means that all the trade agreements that the European Union has concluded so far have been negotiated directly by the European Commission, not by the individual member states. And these potentially could have changed significantly, I would say, the strategy of the European Union, making it more united, more meaningful, more strategic, forward-looking, etc., etc. Unfortunately, at least from a trade union perspective, but this is shared by many in many countries, actually we have faced for more than a decade a very, harsh and limited, I will say, free trade ideology coming from the European Commission when negotiating trade agreements. There have been so far 4 big problems in this coming from this ideology. The first one is that there was a lot of rhetoric about the fantastic economic consequences of trade agreements, but no one has never been able to demonstrate with figures and with, concrete data, what are the real fantastic effects in terms of improvement of not only the GDP, but all the economic factors and elements when it comes to the effects of the agreements. What we have faced instead is that if there is a sector that benefits, there is another sector that is affected negatively. If there is a certain company that benefits, there is another company in the same sector that is affected negatively. It depends a lot on the structure of the sectors, the structures of the 2 economies that interact in a trade agreement, and many other elements. The second ideological rhetoric was about the trade agreements create a lot of jobs. Well, again, it's very jeopardized. I mean, the picture that we have in front of us, because maybe in some sectors, yes, some jobs can be created, but at the cost of other sectors where jobs are destroyed. And very often, I mean, the sum is negative, is not positive in this respect. The third element of this ideological narrative was that for the European Union, human rights, trade union rights, workers' rights, labor rights were not an element in the scope of trade negotiations. So it was a corollary, if you want, something aside, but not in the core of the discussion, as it was not in the core of the discussion environmental rights, consumers' rights, and many, many other elements that, on the contrary, from our point of view, should be part of a more holistic approach to trade agreements. And finally, last but not least, even when the European Union accepted to invent and introduce these sustainability chapters in the trade agreements, and so pushing for some rights to be recognized and to be protected in the framework of trade agreements, well, enforceability was always not happening because there was, again, as Professor Compa rightly emphasized, the conviction that there cannot be trade-related sanctions to enforce rights. These two elements for the European Union can never go together. And we have seen, in fact, that even in some cases where some attempts, let's say, to enforce rights were put in place, the famous joint interpretative instruments that we obtained in the CETA agreement when it was reopened under the pressure of many, many people in many, many countries of the European Union, or the panel to resolve some trade union rights violation in the agreement with South Korea. Even in these cases, these good things on paper didn't create any concrete effect in practice. I mean, we don't have any real enforceability happening. Having said that, in this respect, I think that the USMCA, or whatever is called from the different angles, new agreement is really revolutionary, seen from a European perspective, for exactly the elements that Professor Compa has mentioned, the fact that there are obligations linked to the ILO standards and rights, the fact that there are compliance mechanisms based on dialogue, consultation, but also dispute resolution and legal arbitration, the fact that enforceability is real, that is not only for governments, it's also for companies to comply with these obligations and to even being sanctioned very clearly for violations of trade union or workers' rights, the fact that there are even inspections taking place delivered by the different stakeholders that have an interest in the whole picture. And last but not least, this is also very important, something that the European Union never wanted even to discuss about, it is the fact that trade agreements can create the conditions to incentivize more democracy at work. The Mexican case is very emblematic in this case, can incentivize more enforceability and compliance with rights also in the other countries on the other side of the negotiating table, and that the different actors in the negotiations, the different governments or public authorities that enter the negotiations can make a pressure on the other part, on the counterpart, to enforce and implement labor rights. So the trade agreements can be an instrument to improve the situation when it comes to trade union and workers' rights. In this respect, I think, and I want to conclude on this, I really agree with what Michele just said, that is the fact that this agreement is revolutionary, as I said, and can become really a benchmark for sure the EU next negotiations to come. We have to say that the new European Commission, the von der Leyen Commission, has a bit started a new era in this respect. Poor Commissioner Hogan that was obliged to resign, but he started some kind of new approach, in the sense that he nominated a director in DG Trade for enforcement of trade agreements. He was even available to have a meeting with us and the AFL-CIO to discuss the contents of the sustainability chapter in the USMCA agreement. And there is a different climate, I would say, when it comes to more sustainable and more just trade negotiations to come. There are also some member states in the European Union that are strongly pushing for revising the trade policy of the European Union: France, the Netherlands, Belgium, others. And so we hope that also because of the newly signed agreements like the Mercosur agreement, this monster, for instance, that is not ratified by many member states, is blocked and completely frozen at the moment exactly because of this imbalances in economic terms, economic effects, and not enforceable labor right provisions in the agreement. Well, we hope that this new scenario and the fact that we have the USMCA now could really lead to a different approach and a different environment. Of course, it's not easy. It's also very important that all the actors that are involved in this picture can really play a more active role. And we will see the new commissioner in charge, that is Executive Vice President Dombrovskis, that is going to have the hearing in the parliament in a few weeks, if he will really accept that we really need to build a different approach, a different narrative in Europe in this sense. And if this happens, then it will be also easier to restart the negotiations with the US on completely different basis. So I'm quite optimistic, I would say, because we have been really inspired by what has been done between US, Mexico, and Canada. And I have also to say that our colleagues in there, the US trade unions, but also the good independent trade unions in Mexico, have played a very important positive role to make sure that this agreement could really be enforced properly. Thank you very much.
Thank you very much, Luca. Perfectly in time. Really, thank you very much. It was very interesting what you stressed. We can maybe point out that the labor chapter of the USMCA can be considered a new golden standard for labor provisions. Chapter 23, Chapter 31 maybe can open a new vision on the labor chapter, on the chapters of the trade agreements. We will better understand now the viewpoint of our colleague from Città del Messico, Mexico City, Professor Jorge Carreto Sanginés. We will ask him to stress the relation between the foreign direct investments inflows and the increase in wage. And this is a point that can help us to better understand the queries that we put on the table at the beginning of this round table. Because if on one side we have a better protection of the individual rights because the workers can plead in front of in front of a judge or whatever it is to obtain a sort of justice, a full justice. Of course, we have to balance these norms, these regulation with the labor economics and in general the economics impact of this kind of agreement in North America. Please, Jorge, take the floor, and you also have the 10 minutes, 10 minutes for your speech. Thank you.
Please allow me to share my screen. I will show you a brief presentation I have prepared. I wonder if you're seeing it right now. Are you seeing it correctly?
Yes, yes.
Yes.
Okay. Well, I'll start from the road towards industrialization. Since the end of Mexican Revolution at the beginning of the 20th century, all governments have pursued development in Mexico through industrialization. First, until the 1980s, the strategy followed was import substitution. After the fall in oil prices and the unsustainability of foreign debt, the strategy was changed, liberalization of the economy and integration with the United States. Both strategies implied cost. Comparative advantages had to be created to attract foreign investments. During the import substitution, the two main levers to create these comparative advantages were the fixed rate of exchange and low wages. When foreign deficit became unsustainable, import substitution was abandoned. Economic liberalization instead freed the exchange rate, but kept the low wages. Liberalization wasn't actually for everybody. And here we can see that the free trade agreement in reality was an administered trade agreement. There was no freedom for everybody, and protectionism and trade wars are putting an end to this free market. What will follow from here? So these fundamental instruments of import substitution policy were the 1962 presidential decree, which decreed that at least 60% of direct cost of production of vehicles have to be manufactured within the country, and the 1964 Programa Nacional Fronterizo, where the maquiladoras were created, providing mainly cheap Mexican workforce, mainly women, for this industry. The import substitution policy was challenged when high levels of inflation and a debt crisis forced a process of economic restructuring based mainly on the resizing of the state of the economy and a productive restructuring and commercial opening. The 1983 decree of modernization of automotive industry, the 1986 entering of into GATT, and the 1994 NAFTA. The path towards industrialization changed. Import substitution policy was abandoned and free market policies replaced it. Expectation about the dynamic effect benefits of integration previewed a conversion in terms of productivity, real wages, and per capita income in all the NAFTA zone. Well, parallel to the liberation policy, government, business leaders, and labor organizations signed several pacts since 1987 until 1996, in where the government promised to observe financial discipline to reduce this risk. Labor organization agreed to limit wage increase to reduce cost, and business leaders promised to limit the increases in prices of goods and services in order to reduce inflation. In fact, inflation was controlled, and mainly those who paid were the laborers. The legal framework was, in the beginning, the 1970 labor law, which established fundamental principles, mainly freedom of work, labor equality, revocability of labor rights, participation of workers in the profit of companies, and regulated individual collective labor relations. And then there was a reform in 2012 with an evident bias favoring employers, which is expressly stated that its object was to increase employment, no matter what kind of employment. It recognized outsourcing as a legal form of contract, created new temporary contracts and protecting factors, and labor training was mandatory. Also, they reduced the cost of legal cost of dismissing a person. Now we have the 2019 reform to labor laws that Compa has just outlined, and I will just remember that it establishes rules that protect individual and collective rights. A very important thing is that the board that before was where they were las juntas de conciliación, where the conflicts were resolved. Now it passes to the judiciary branch. Now outsourcing is regulated, labor relationships simulation are banned, and also wage discounts. Here we can observe the evolution of annual wages in Mexico on the left panel. You can see that the wages in the car and trucks assembly, mainly in the production of cars and trucks, the wages are very high with respect to the rest of the manufacturing industry. And on the right panel, you can see that the wages in the United States are more than $20 per hour. Instead, in Mexico are less than $5 per hour. And it has remained flat for all this period since 2003 to 2017. So there hasn't been an increment in wages. Employment has grown mainly, as you can see in the lower panel, has grown mainly in the sector of transportation equipment, and it has grew its share within the employment in the whole manufacturing industry. Here you can see that the annual foreign direct investment, which has been the main object of all these reforms and all these pacts and policy measures that have been taken by Mexican government. And you can see it goes all the way to almost $35 billion each year in 2018. Now, the USMCA has several rules concerning regional value content, 75% for core parts and 70% for principal parts, 65% for complementary parts of automotive. Steel content has to be 70%, aluminum content has to be 70%, and labor content has to be 40% for passenger vehicles with $16 per hour and 45% for truck and heavy vehicles. The thing here is that although there are 7% different percentages for the different costs within the production of the vehicle, materials and manufacturing cost, and R&D and IT, and engine transmission or advanced battery assembly. But the thing is that they can average all these within the North American region. So a vehicle can be produced with low wages in Mexico and high wages in the United States, as long as the 40% of this cost is above $16 per hour. If there is no more low-cost comparative advantage, what will be the competitive advantage of Mexico to attract foreign investment in the future? So it is expected that the agreement will strengthen labor standards and rights, collective bargaining. Mexico commits to recognize the rights of workers, and the United States Trade Commission estimated in 2019, excuse me, here's a mistake, that these provisions would increase Mexican union wages by 17.2%, assuming that these provisions are enforced. Now, there is uncertainty with respect to the future industrial policy in the United States. Dependence on the United States demand is a vulnerability for Mexican economy, and there seems to be an absence of an industrial policy, which is in itself an industrial policy. The compliance with the USMCA labor rules could imply a significant loss of competitiveness, either by wages becoming expensive or by having to pay tariffs if not complying. Competitiveness could be lost also due to gaps in supply chains and scarcity of skilled laborers. Then how to build a new competitive advantages that do not rely on workers having to pay for them? There was expectations that the USMCA would increase employees in the automotive sector in the United States. They expect higher wages in the three countries, higher union wages in Mexico, a moderate effect on the US economy, etc. The thing is that is a labor reform, kind of a labor revolution, really attainable through the imposition by a foreign trade union? I mean, there is a lot of work to be done in Mexico in order to comply with all of this. And I will leave here my presentation, and thank you very much.
Thank you very much, Professor Carreto, for your speech. It was very interesting. very good presentation of your viewpoint. Now it's time to leave the floor to our colleague of the European Economic Social Committee, Cinzia Del Rio. I will ask her to provide us with the European Economic Social Committee understanding of the labor standards in trade agreements. We will be happy also to understand if in these last years the committee had the chance to focus on the ISDS clauses and the relation between the ISDS clauses, the financial responsibility of member states, and labor standards. We know that this is one of the most critical points within the trade agreements and the European approach to the forthcoming agreements. Maybe Cinzia can help us to better understand that. Please take the floor. Thank you very much.
Yes,
10
thank
minutes,
you.
as we say.
Yes, I'll try. I'm Italian. Thanks for this introduction, and it's very useful to understand a bit more how the system under the USMCA works. As you know, the European Economic and Social Committee is a European body made of 3 groups: workers, employers, and diverse interests, which represent anyway the civil society. We have addressed as Economic and Social Committee several issues, in particular in the last months. So I will focus mainly on this, in particular the implementation measures of TSD chapters in EU trade agreements with third countries, enforcement measures, supply chains, decent work in supply chains, which is a very big issue under discussion in the committee. And last week, we have adopted a proposal for a binding legislative directive at EU level on due diligence, which enters into the discussion that we are having on dispute resolution mechanism, with a proposal coming from our side. So agreed among the 3 groups. I come from the trade union side, so I share what Luca said, but I'm trying to be balanced here in order to present to you what the 3 groups have agreed. First of all, I think it is important that we understand the legislative framework, because I see differences between our approaches. We are committed to have a consistent approach in our activity, aiming at linking the respect of human and labor rights, the implementation of SDGs, the promotion of sustainable investments in trade agreements and business operations across the world, but together with strong industrial relation systems, strong collective bargaining, and effective social dialogue. These 2 aspects have to go together. When we talk about labor rights, we refer to ILO international recognized fundamental conventions. This is why, for us, therefore, labor standards, I understand Professor Compa, but for us, it's not sufficient to talk about the principles of the ILO declaration. We look at the normative wording of the conventions. This is why we ask in all the trade agreements of the EU, the ratification of the 8 fundamental conventions, and we would like to add also a framework convention on health and safety, which is not part of the 8 fundamental conventions of the ILO. So there is, from this point of view, a big difference in the approach, in the legislative approach. it is important to understand this legislative framework in which we frame our opinions as a committee. At EU level, we have a number of directives which refer to labor rights, but it is essential to ensure equal competition among European enterprises in the internal market. This is the reason why we have addressed all these issues. The challenge is to define a common playing field addressing legislative loopholes at European level, but also outside the EU borders in the supply and subcontracting chains, with binding enforcement measures, proportionate sanctions, clear remedies for the victims if an infringement occurs. And this is another very difficult area to address. We know that all the voluntary instruments that we had at international level, the UN guiding principle, OECD guidelines, and the number also of corporate agreements, the ILO tripartite declaration on multinationals, all these attempts have failed. Let's be very clear. Voluntary measures have not been able to prevent grievous violations of fundamental rights, but also they were not able to offer companies legal certainty. This is another request by the Group 1 of the EEC, legal certainty when engaging in business relations abroad. All this picture has led to a patchwork of measures adopted at national level by some member states, aiming at enhancing corporate accountability and establishing firmer frameworks for human rights due diligence, which is becoming more and more a matter for good functioning of the European internal market. The picture is very fragmented with different tools and different impact as far as the respect of labor rights is concerned, with different member states attaching differing legal sanctions to the behavior of firms. The French legislation on due diligence and some aspects of the Dutch legislation on core labor rights can be an example of the different approach at the national level, which might create unfair competition among the European enterprises. This is the approach that we are dealing with. Of course, there is also an ethical component that coming from the trade union side, I cannot but underline when we talk about respect of labor rights. The EC has urged the European Commission to take the lead and work for a consistent approach and develop a European action plan on human rights, decent work, and sustainability in global supply chains, in agreement with the European Parliament and the Council. And we have called, in the opinion adopted last week, for a binding cross-sectoral legislative initiative on human rights due diligence and responsible business conduct, which should cover all companies, also SMEs, established or active in the European Union, including their supply and subcontracting chains, as well as the public sector and public procurement acts. This is another very important area in public procurement, which are the rules under public procurement. The legislative instrument should apply also to companies of third countries selling a significant volume of goods and services in the European Union. This is our proposal. You can have the full text is now public. There are some questions which remain open, and this is for the discussion because, of course, the example of the dispute resolution mechanism in the USMCA is very interesting. I wouldn't call it the new golden standard for labor protection, Michele, I would be very cautious, considering the legislative framework on which we would like to put the basis for labor standards to be recognized. Anyway, which liabilities for European enterprises in case of misconduct? This is the EC proposes a liability resulting in effective remedies for victims of misconduct, a specific liability framework, including criminal liability for cases where human rights, social and environmental standards violation occur, including in their supply chains. But which is the legal entity in third countries which can intervene to assess, monitor, and collect complaints? This is one thing is to be able to act at European level under the European legislation, making use also of the European Court of Justice, and one thing is to be active in third countries. Who should decide the sanctions and remedies outside the European borders in case of supply chains in third countries? It is clear that the TSD chapter lacks a credible enforcement mechanism in order to induce compliance with obligations. The EC proposes, in the opinion that we have adopted, a specific forum conducting fair proceedings and with jurisdiction, and the modification of the Brussels I regulation to allow for a proceeding in Europe. We need to ensure legal certainty and practicability of the applicable law. A reliable dispute resolution process is necessary in FTAs, and it has not been activated in any FTA, not even in front of the violations in South Korea. To be clear, we had no possibility to act under the present rules, as Luca said, in the trade agreements. But this needs to be discussed and agreed, and of course we can take advantage of this new agreement between US, Canada, and Mexico. But I would like to raise also another question, which we have discussed a lot at European level, about the role of WTO.
Just
yes, the role of WTO and the role of the ILO. We strongly oppose the WTO to deal with labor standards. We propose the ILO to have a permanent observer status in the WTO, but the WTO has no competence on labor standards. We propose, what is the role of the ILO? Can we use the ILO and give the ILO a judicial role, not only to collect complaints, but also to deliver sanctions and remedies? This is a question mark, because otherwise we need to avoid to work only on bilateral solutions, while we should look for a multilateral approach, because otherwise we will have different systems according to the trade agreements, and this would be really unfair and unbalanced. This is the approach that we are discussing at European level. I hope that it's to give you some hints for further discussion.
Thank you very much, Cinzia. Thank you. I appreciate also the fact that you were very frank, also with me, very good. What I'm stressing since the beginning of this roundtable is that, in my view, the labor enforcement mechanism is creating a new generation of labor chapter that is quite new. I mean, maybe it's the first time. I don't know. Lance maybe can, in other occasion, can we will have the occasion to stress this point, but this is very interesting. And this is the point around which, as European scholars, as European experts of this matter, we have to focus for the future. Because we understood that in the Canadian-European agreement, we were able to improve some points that were not in line with what, as Europeans, we believe that was in compliance with our labor and industrial relation traditions. Now it's time to find something that is new, a new generation, if I can say. I also say that gold standards, maybe, but we will see. And together, the chapter 23 and the chapter 31 are a very good platform to understand also for the forthcoming European agreements. But now it's time to give the floor to our colleague Piera Loi, professor of labor law at University of Cagliari, well-known scholar of international European labor law. I will ask Piera to focus on some points, in particular the bindingness and sanctioning mechanism in the trade agreement. I will ask her also to focus on a new possible path to regulate the human rights due diligence. And she has the experience to give a deep insight on this topic. So please take the floor. Piera, you have 10 minutes.
Okay, thank you, Michele. Thank you, everybody, for inviting me to this very interesting webinar. First of all, I would say that we all agree that international trade agreements are second best in solution in implementing labor standards. We know it because they are imperfect tools, but we have been obliged a long time to use international trade agreements as an alternative to the difficulties that ILO and other international instruments had in implementing, in giving effectiveness to labor rights. But we have to bear this in mind clearly, that they are second best tools. So they are full of, let's say, problems. So the social clauses that we have been studying in all these years can be defined as mechanism to reduce negative externalities. So I propose these ideas that social rights are can be seen as negative externalities in the cause lessons, following cause lessons, and that social clauses in trade agreements are mechanism to reduce these negative externalities. How can we discuss this? I don't know if do you see the presentation maybe or not? You don't see my presentation. Okay, well, maybe I will try again, but if not, it's okay. I think that it will be okay. We can say, for example, if we have two or more countries signing a trade agreement, a country A with lower labor costs and a country B with higher labor costs, the differences in labor costs between these two countries entering in a trade relationship can produce a negative effect, a negative externality on the country with higher labor standards, like in the case of the Mexican and Canada and United States agreements. There is a kind of social pollution from the country A, let's say Mexico, to the country B or C, like United States or Canada. So Mexico, with its lower labor costs, can produce a negative externality that should be reduced, because it is able to produce social dumping phenomena. a kind of race to the bottom of social protection. This is clear, in my view, in what the same President Trump said. President Trump presented this agreement, saying that this trade agreement is an agreement for United States worker. So it's a kind of protection from any race to the bottom of social protection. So when you have strong social clauses in trade agreements, like in the case of the USMCA, referring to the ILO and other international standards, together with a monitoring and sanctioning system, as Lance Compa has said, this can really help reducing this kind of negative externality. But anyway, we have some difficulties also in this kind of trade agreements. How you can make social clause effective. First of all, it's not always simple to decide and easy to decide if a trade agreement creates harms, like negative externalities, or create benefits, like positive externalities. And also, you know, the sanctioning mechanism is also questionable because, for example, the violation of the social clause in a trade agreement could entail a prohibition or a restriction in trade. And this could be interpreted as an unjustifiable discrimination for a certain country. So the trade agreement needs a justification in the case of violation of the social clause. So in this case, we actually need a balancing, balancing as a kind of strict proportionality test, saying that the benefits of the measure against the restriction to trade are justified, let's say. Is there any lesson from the EU from this point of view? Is there any lesson from the activity of the trade policy making of the EU a long time? It seems that, as Visentini said, and also as Cinzia has said, that the EU trade policy making, its system of sanctioning, and even the recent system of incentives with the GSP Plus has created a lot of criticism about the effectiveness of this trade and sustainable development chapters. So that's why I find very interesting these new regulatory avenues like the due diligence in human rights approach. First of all, because it's clear that from this approach that the subject of this new approach are not only the states, I would say, but are the subject, the enterprises. And it's important that enterprises could be sanctioned in the due diligence approach. The most interesting thing in due diligence approach is that social rights are conceived in terms of risks. So enterprises should identify the social rights risks caused by their activity, and they are obliged to set up policies and initiatives in order to reduce these risks. Of course, we are not sure that this approach will cause this approach of the due diligence in human and social rights approach will provoke or could guarantee more effectiveness to the protection of social rights. But it's worth trying to follow this avenue, in my opinion. And another question which is open to discussion is that the effectiveness of social clauses and the reduction of negative externalities need anyway a sanctioning system, or we have to to abandon a traditional sanctioning system and use a monitoring and assistance system. But as Cinzia said, maybe it's time to realize that any monitoring system without a sanctioning, a proper sanctioning system, could not function. So I would put myself in between Michele's optimism and Cinzia's pessimism, let's say, saying that we need sanctioning systems, we need proper sanctioning systems, but it's better not to have, you know, my problem with the treaty, with the USMCA treaty, is that finally there is only an arbitral system imposing eventually sanction. I would prefer a proper jurisdictional institution able to to decide which sanctioning system is better to use in that sense. I think I do not use any time, so I stop here. Thank you.
Thank you very much, Piera, for your speech. Very good. Your time is okay. Now it's time to ask Annamaria to take the floor for the conclusion. I would like to thank you all. Thank you very much for your very qualified speech and the chance that you gave us to exchange ideas on this topic. But I'm sure that we will have in the next future further occasion, opportunities to meet virtually or in presence, we will see, and to see how this new labor chapter will work or is working. Thank you very much. Please, Annamaria.
Yes, thank you, Michele. Thank you, all of you. I learned a lot. I realized that the time is short, so I will simply react to some of the points that have been put. Starting from the Michele question, does the USMCA change things? And if it does, who benefits? Can both Mexico and the United States benefit from this labor code that is included in the treaty? And here I think that perhaps Jorge was, as an economist, was pointing out to the possibility of a trade-off. I mean, he has tried to show that the growth in the automotive industry in Mexico was based on foreign investments, and it's mostly foreign firms that are benefiting from the low wage, low labor standards of Mexico. So, is there a trade-off between the growth of a sector and the level of wages that this country, developing countries, compared to the United States, can afford to pay? This is a question that I think is bothering the Mexican authorities. And I mean, these laws this trade agreement is actually meant to foreign firms. And foreign firms can come in and can go out. One point, I think, in favor of the possibility to increase labor standards and wages in Mexico now is perhaps based on the fact of sunk costs. Those firms, those OEMs and tier one foreign firms are there, and there are costs to get out and to lose access to the US market. So this may give some layout for increasing labor standards, but nonetheless, there might be a problem in, Lance Compa said that the US trade unions are in favor of these codes. And this is the drama of the working movements in different countries, that they are often put one against the other. And so what happens with the employment in Mexico is a problem or can be a problem. And this doesn't mean that we need to have low wages. But here again, one of Jorge's argument or question best is, can a labor reform be imposed from abroad? A point which was also, I think, mentioned by Cinzia Del Rio. So will it be effective? And I was in Mexico at the beginning of this year, and I know that the independent trade unions were in favor of the labor clause because they saw it as a way in which you could shake the government and try to make a change in the labor market. Nonetheless, I think that if there is not an industrial policy accompanying the labor laws, trying to shelter employment and the domestic firms from a too strong effect, this treaty can go bad. So you need labor laws and you need a policy, an industrial policy to protect jobs. One without the other, I think, won't work. And the last point is related to the trade agreements. I mean, do you need a trade agreement to enforce labor laws? Well, think about Europe. We have in Europe the CE, the Central and Europe and the Eastern countries that are very much in the same situation of Mexico. In the Czech Republic or in Hungary or in Poland, the wages in the automotive industry are 25% of the wages in Germany. And the labor conditions, labor laws there are not so bad, but not much better than in Mexico. So there is this contradiction once again, not only across different countries with different trade agreements, but within a common market, you have countries that are on a different level of labor laws, labor guarantees, and this is social dumping. So once again, you can understand when Jorge is saying you cannot really impose a labor law from abroad unless there are different power relations between the two countries. And this, I think, is a bit what perhaps some part of the Mexican are resenting, because Hungary, the Czech Republic, won't accept the same labor law enforcement, and they are not accepting it. And they are actually applying social dumping for the workers in Italy, in Germany, in France. So the thing is, from an economic point of view, is more complicated. And I mean, the main point I would make is that you only defend labor laws and wages if you have a cooperative macroeconomic and industrial policy. You have, first of all, to guarantee jobs, and then you can also guarantee wages. Maybe, I don't know.
Thank you very much, Anna, for your conclusions. It was very interesting to see your viewpoint, to understand these differences. I would like to thank you again, you all. Thank you very much for joining us, and also to thank all the colleagues around the world that decide to follow in live streaming this virtual panel. Thank you again, and we will have a chance to meet again, I'm sure. Grazie a tutti. Thank you. Bye.
Arrivederci.
Arrivederci. Arrivederci, grazie. Bye bye.
Bye Lance. Bye. Arrivederci. Bye Jorge.
Bye everybody.
Bye.